Hey, what's up, guys? How y'all doing today? Well, if your name is Sean Diddy Combs, the feds are not done letting you know things are not playing out the way you thought it was. Now, get this. Diddy's team thought they were making waves. They thought they were getting some motion. They thought they had the feds backed off on their heels. They were demanding that he wanted to be released from jail ASAP. The feds already told the second court of the appeal panel, the three judge appeal panel, that's not happening. Diddy is a danger to society. And as much as they want to make this about Cassie, baby, we got proof. On top of that, Dawn's lawyer came out and said the proof is us because he did the same thing to us. However, it's not over. Remember Diddy's insane request, and we said it was insane a while back, that he wanted a name of all the witnesses accusing him of everything before they even get to discovery was ridiculous. And the federal government was not going to go for that. Guess what? The federal government has literally told Diddy, baby, you can keep parking yourself in jail. We will not be coerced. We will not be bullied. And I don't know how much you're paying your lawyers, but you need a refund because this is an exercise of seeing who can get Justin's car payment before all the money goes away. If you guys don't know, there's also some issues going on with Justin and Diddy. His car is about to be repossessed. Meanwhile, Christian is riding around in a new car. Child, when I tell you we got so much to discuss, but let's get into the actual legal action because that is the part that is the most disturbing, surprising, but it makes me feel good that the feds are fighting hard to make sure that justice is done and Diddy is not going to get away with it. If you missed my video from last night, it basically went into how the Fed said we have years, not just a few months, but we have years approach that Diddy, the reason we said he was running a RICO is because he systematically, every time he's accused of something, goes to witnesses, bribes them, intimidates them, coerces them, does what he can to kind of gut the investigation so nobody will testify. And then he goes on with their life. They said, we seen your MO. We saw it from the door. This is not a month long, 2 month old, 3 month old. This is a years long, some would even say decades long problem. The feds have called them out. So Diddy requested to identify all the alleged victims in his criminal case. Listen, the Fed said, "No." They literally hit him with the, "We really don't know what to do with that." What do you mean? Let's get into this letter because, baby, it is so hilarious. And shout out to the Inner City Press for actually posting this. The Diddy Docket said the United States U.S. attorneys has asked for more time to respond to Diddy's demand for all victims' names, citing denial by the now Second Circuit Judge Nathan of a similar request by just saying Maxwell, saying denying as a premature motion for disclosure of alleged victims' identities. Okay. Now, why is that so important? Let's break this down into real talk. Well, let's read the letter actually. Um, they said the government respectfully writes to request a deadline of October 30th, 2024 to file its response to the defendant's motion for a bill of particulars under Federal Rule of Criminal Procedure 7F, dated October 15. The parties conferred regarding the government's proposed deadline. The government understands the defense's position is that the motion is unusual and an emergency, and the government should be required to respond by Monday, October 21st, 2024, less than 1 week from when the motion was filed. Now, again, this was very strategic on Diddy's lawyers. They thought they could push around the government and say, no, we want a speedy trial. We're rushing. We need the information. Give me. Diddy's constitutional rights, out of this, that, and the third. The government, by doing this, is saying, pause, cool your jets. You chose to make this run faster. However, we still have time. As much as you want a speedy trial, you still have to allow the norms of procedure. When you put a motion in, you usually have 10 days for the other side to respond. We have not had our 10 days. The fact that you want to rush this to the finish line, that sounds like a you problem. We have time and we will be thoughtful and methodical with each step we take. Again, people are saying that this was Diddy's team's insane. I think they ran this like they were just talking to another um civilian or civil attorney. You are talking to the United States Attorney's Office. They will not be brushed. They will not be bluffed. They will not be embarrassed or smeared or humiliated, especially Homeland Security investigations in the media. Again, we see the play that they're running, but it's just not working. They said the government should be permitted to respond to the Rule 7F motion by October 30th, 2024. Again, you usually have 10 days to respond to motions. Um, the government is currently scheduled to respond to a different defense motion, the motion relating to the purported grand jury leaks. Now, here they're using Diddy's own words against them. Remember, you were crying that the Department of Homeland Security was leaking things and We're busy responding to that motion. Again, it's a legal strategy. I don't know if it's the smartest one with the government. That Diddy thinks that they hit them left, right, and the third with all these motions. The government will become flustered and roll over. The government is saying that's not happening. We are, will continue to be, and always were in control of this Diddy. They said, the government is scheduled to respond to a different defense motion, the motion relating to purported grand jury leaks. By that date, and consolidating the government's opposition to these two motions will promote simplicity in a procedure and fairness in administration. See Federal Rules of Criminal Procedure, Rule 2. Moreover, the default deadline to respond to the defendant's motion is set forth in Local Rule 49.1 and should be October 29th, one day before the date requested by the government. The Rule 7F motion does not require a quicker response. Again, they're telling them, slow the F down. Diddy is going to jail for the rest of his life. I love the way that they are going through this mess with his team. We love to see it. In fact, as the government will more fully address in its opposition, the motion cannot meaningfully be evaluated at this stage prior to the completion of discovery, and the government should be permitted to respond to any remaining disputes following the close of discovery. They actually cited United States v. Marshall. It was the Southern District of New York, August 25th, 2020, denying as premature a motion for disclosure of alleged victims' identities prior to completion of discovery, and rejecting defense argument that it's critical for the defense to know the names of victims as soon as possible. Okay, they're also saying finding that a bill of particulars was not required where the discovery provided to the defendant enabled him to understand the nature of the charges against him and to prepare defense and to avoid unfair surprise at trial. Now, listen, it's no surprise that Diddy's lawyer, one of the lawyers that probably suggested this, actually represented Ghislaine Maxwell. And it should come as a good feeling that Ghislaine Maxwell is doing, 40 years in jail? Let me tell you something. Diddy's team is the team he deserves, and we love to see it. But more importantly, and I think this actually should be mapped out, okay? Diddy tried to rush the government. Diddy is saying, after being accused of witness intimidation, coercion, the government in its emergency filing last night said they have proof that he doesn't just go through himself, he goes through his intermediaries. So if we let him out and don't closely monitor him, he's just going to have his henchmen do the dirty work. They said they have countless proof. Now, interestingly enough, right? They're also saying you have enough to defend yourself. Did you do the sex trafficking or not? Did you hire the prostitutes or not? Did you kidnap, put a bomb? You have enough. Okay. And it is a defense to say, I didn't do any of these things and I can prove it. You do not need to know every single witness that we're bringing up to prove that you did it. Because what happens is in discovery, they have all those terabytes, right? They have all those terabytes that they actually need to get through. They are still making a witness list. They are still doing that. They are going to be co-defendants. But getting back to this, after discovery is when you move to trial and each side gives a list of witnesses they're going to call. That's when you get the list of who's going to prove what that you did. But the fact that we're accusing you of this, we don't need to give you any more names, especially considering maybe intimidation, witness coercion, obstruction of justice, threatening violence. That's Diddy's middle name. Forget about love. Love to do crimes. Sean Love Combs. Anyway, you guys, listen. This story is developing. I'll hop back in. I got some new information. Let me put my put my ear to the street and see what the prosecutors are saying. Okay, and by prosecutors, I mean, little birdies. Anyway, y'all, I am not speaking to prosecutors. I just want to make that clear. But let me actually get on it, and I'll talk to y'all later. Bye.